Ready? Start. The respondents number 1, 2, 3 herein are the legal heirs of the deceased employee Shri Sandeep, who was employed as a commercial driver by respondent number 4. Stop. On 13/2/2017 at about 1 p.m. when Shri Sandeep was driving the offending vehicle Maruti Swift Dzire Cab bearing registration number HR 63C 6448 registered in the name of respondent number 4. He collapsed. Stop. The passengers accompanying him in the car brought him to casualty where he was pronounced dead. Stop. Pursuant to the said incident, the respondents number 1 to 3 preferred claim petition on 13/7/2017 seeking compensation under Employees Compensation Act, 1923 before the Learned Commissioner, Labour Department, Delhi. Stop para. Learned Counsel Shri Salil Paul, appearing on behalf of the appellant, has submitted that Commissioner vide order dated 8/2/2021 held that so cause notice dated 19/11/2020 was sent to the respondent number 4 to appear on 18/12/2020 and so cause as to why penalty up to the extent of 50% of compensation amount be not imposed upon for not depositing the compensation within time when it fell due. But respondent number 4 neither appeared nor filed any reply to the said so cause notice. Hence, the Commissioner vide order dated 8/2/2021 had rightly held that respondent number 4 was not interested to defend itself and his opportunity to file reply was closed. Therefore, he was held liable to pay the penalty. Stop para. At the outset, it is apt and appropriate for us to consider the scope and objective of the Employees Compensation Act, 1923 before we delve into considering the submissions on merit so that we could give effect to the purported legislative intent to the provision in question in its true perspective. Stop. The perusal of the statement of objects of the said legislation makes it crystal clear that said legislation is a social welfare statute brought in by the Parliament to redress the grievances of the employees in case of accidents that may occur in or during the course of employment by payment of adequate compensation expeditiously so as to enable the employee or his family to defray the medical expenses of employees in case of injury or sustained livelihood in case of death of an employee. Stop para. Therefore, the conclusion becomes inevitable that when an employee suffers from a motor accident injury while on duty on the motor vehicle belonging to the insured employer, the claim of compensation payable under the Compensation Act along with interest thereon, if any, as imposed by the Commissioner.